Mr. Chairman, honorable members, good morning and thank you for the invitation to present our annual report for last year. Let me start by making a few references to what we did in 2016. Last year we witnessed a series of political earthquakes in the EU and around the world. We shall see whether this disruptive trend will continue this year. But in 2016, you also built something strong enough to survive the winds of political change. In particular, with the General Data Protection Regulation and the Data Protection Directive for police and law enforcement, the EU has led the way around the world in safeguarding fundamental rights in the digital age. And this great achievement is a tribute to the resilience and expertise demonstrated particularly by this committee during the 4 years of difficult negotiation and intense external pressure. At EDPS, as a regulator, we handled last year more complaints than in any other year since EDPS was established. This is not necessarily to be interpreted as a criticism of how EU bodies are handling personal data. Rather, it is to be seen as part of a generalized trend in which individuals are becoming more and more aware and concerned about how their digital selves are respected. Data protection is mistakenly portrayed as a technical and legal issue, but it is fundamentally about real people. At EDPS, my staff deal every day individuals who are worried or angry about what may have been done with information about them. Data protection has been established in the EU as a fundamental right to serve the interests of the individual in the face of powerful corporations and government, but it can also be misinterpreted in ways which do not serve the interests of these individuals. For example, when data protection is falsely opposed to the public interest for transparency. Let me give you a practical example from last year of how European Union bodies are thinking through this question with our guidance as a regulator. The Council's Equal Opportunities Office does some great work in raising awareness of what it is like to have a disability at the workplace. And their promotional videos and other materials include information about actual individuals and their conditions. Such information should only appear if the individuals concerned have given their free and informed consent. So we have worked with the Council to find practical ways for the people in question to understand and freely choose whether their information should be used in awareness raising. And we launched last year a project that aims to bring about a culture change in EU institutions based on the principle of accountability. It began with an internal exercise among our own staff led by the DPO of the EDPS before we began to roll it out to other bodies. And I met personally the heads of the European Central Bank, the Fundamental Rights Agency, Council Secretariat, the Court of Justice, the Secretary General of this Parliament, and therefore we see our role to equip you and other institutions with what you need to be able to scrutinize legislation more efficiently and hold the Commission to account. For example, the recently adopted toolkit on the notion of necessity we published last month following consultation last year was a direct response to the needs expressed by this committee in the last couple of years. And later this year we will publish guidelines on proportionality as we attempt to make it easier to apply legal principles which are not always self-evident. We have also had to deliver difficult messages to you as a co-legislator, such as the one on the proposed Digital Content Directive. In this case, we recognize the good intentions behind the proposals, but we were obliged to highlight the major unintended consequences of, in effect, legalizing the sale of one's personal information in exchange of services. At EDPS, our role is expanding as a result of the decisions taken in this House last year. And this week we became the supervisor of how Europol processes personal information. We are accelerating our knowledge of the complex decision points facing people on the front line of law enforcement and border management. We just published another opinion on the proposed regulation on the revision of the legal basis for the SIS2 databases. And we are about to issue a statement on the Commission's proposal on interoperability of information systems. And I would like to thank you for the invitation to join a hearing end of May. Last year, we also worked to promote the longer-term strategic priorities for data protection. I would like to only focus on 3 examples. First, we are introducing an ethical approach to the questions posed by artificial intelligence and other data-driven technologies. Last year, we appointed an ethics advisory group of eminent persons from a diversity of disciplines, not only lawyers, and next week we will host here in this building a workshop to learn from ethical traditions from across the scientific community. Second, we have continued to facilitate privacy engineering through particularly the IPAN network, which gets bigger every week. And this year we will rely on the input from this group as we develop an opinion on the notion of privacy by design and privacy by default. And third, we have launched the Digital Clearinghouse, drawing inspiration from the report on fundamental rights and big data prepared by Mrs. Gomez in this committee on behalf of LIBE earlier this year. So consumer privacy and antitrust authorities will meet for the first time this month to discuss how to promote the interests of individuals in the face of unfair practices online. This is what more or less we have done. But what is missing? I think the EU has much to be proud of in this area of privacy and data protection. But we must realize that data protection and privacy laws are proliferating around the world. 121 countries now have such rules in place or on the negotiation table. And most of these have been inspired by or replicate the principles developed in Europe by the EU and the Council of Europe. But these are also contradictory trends, trends towards the use of big data in order to coerce society and individuals into certain forms of behavior. What we lack is common consensus for bringing together this community of data protection jurisdictions. The Privacy Shield is perhaps the most high-profile and controversial attempt to codify such a consensus between 2 major trading partners. I was in Washington, D.C. 2 weeks ago, and it's true that the EU still awaits signals of willingness to build this strategic partnership. My message was to our partners to focus on compliance with all the relevant safeguards contained in the GDPR and not just on rules for transfers of data outside of Europe, to consider the new scope of application of the GDPR. We will contribute through the Article 29 Working Party and in future with the EDPB to the joint review of the Privacy Shield, in particular what is planned for this year. And another thing that is missing, in my view, not for much longer, I hope, is modern rules to apply to us, to European Union bodies, which process personal information, in few cases very sensitive data. So Regulation 45 reform is essential. And as I said yesterday to the rapporteur and shadows rapporteurs in this committee is crucial because it is a statement that EU intends to apply to itself the rules which the legislator has devised for others in the GDPR and in the Law Enforcement Directive. So no room for special treatment for EU institutions. And the strongest way to send these signals is to adopt these updated rules in time to them to be fully applicable on the very same day of the GDPR, day 1, 25th of May next year. We have worked hard to ensure that institutions are anticipating these rules and will need, therefore, very little time to prepare. Then there is e-privacy. And the current negotiations on this new regulation are perhaps more important than the GDPR in the longer term, because the distinction between personal data and non-personal data, metadata, becomes less and less stable and meaningful with self-learning machines able to identify individuals using almost any information, including anonymized data. What will be left is communications between people, increasing mediated by machines on their behalf and sometimes without their knowledge. So we must therefore ensure the confidentiality of communications so that the next generations can have more confidence that they have an intimate, inviolable space for talking to one another, and that this space may be interfered with only their informed and free consent. A final remark on what we will do. You have done your job, but now the baton passes to the regulator. And the DNA of data protection authorities, including the EDPS, involves multiple functions, from fielding complaints, advocacy, providing guidance, sanctions, and giving advice to lawmakers. If we pursue the genetic analogy a bit further, we might say that accountability is the bonding, the backbone, which ties these different functions together. So DPAs in the EU, like us, must be more proactive and more solution-oriented. We need to make compliance easy, but also enforce the law with the full rigor permitted by the law. I would like to thank the President of this Parliament and the Secretary General for their active support and vision in agreeing to allow us to host next year the International Conference of Data Protection and Privacy Commissioners in this building from 24th to 26th of October 2018, the Olympic Games of privacy and data protection involving all regulators in the planet. This will enable the EU to showcase its commitment and professionalism before the worldwide data protection and privacy community, and this will take place during the Parliament sessions in Strasbourg to minimize disruption, but I will welcome your participation on the last day, Thursday, to the fullest extent possible. So, Mr. Chairman, honorable members, 2.5 years ago, you gave Wojciech Wieworowski, Assistant Supervisor, and me the mandate to develop and communicate a global and practical vision and to build and maintain at the highest level effective relationship with diverse stakeholders in the EU institutions and around the world. And we enter now, in few weeks, the second half of this mandate. We intend to complete the reshaping of our institutions so that it is fully fit for purpose. We will be investing energies in ensuring we have the right people and skills for our new governance responsibilities and advisory role towards you and other institutions, for monitoring technologies more closely, and of course for providing a world-class secretariat to the new European Data Protection Board. So I can simply conclude now, dear Chair, to say once again thank you for your support and engagement over the past here, and of course to all of you today for your attention. I look forward to our brief discussion today.